All right, now we're going to look at some exceptions to our search rule. Last time we looked at searches, we realized that police need probable cause in order to search. Sometimes they need a warrant, sometimes they don't. But there's a number of exceptions that fall around this that we need to talk about. One of those exceptions is the area around the lawful arrest, also sometimes referred to as the incident to a lawful arrest. Basically what that's saying is, if somebody is arrested, they can search the area around that arrest, even if it's not, and they don't have probable cause to search it. So let's use an example where someone is pulled over for some kind of traffic violation and they have an outstanding warrant out on it. Okay, so that's a lawful arrest. That person is arrested. Well, in their car then, or their car is the area around the lawful arrest. So even though they don't have any probable cause to believe that there's evidence within the car, because it falls within the incident to a lawful arrest, they can search that. Let's say that there's a passenger in a car and the passenger's purse is sitting next to the man who was arrested. That falls within the incident to a lawful arrest. Cell phones, however, the Supreme Court has just recently ruled, do not fall within that, meaning that they can take the cell phone, but searching through the contents of the cell phone may not be legal, even though it is in the area around the lawful arrest. That's based on 2 Supreme Court rulings just from 2014, I believe. There's another search called a stop and frisk, or sometimes referred to as Terry search. And a Terry search or a stop and frisk search, also known as a pat-down search, is a search in which just that, someone is patted down. Now, in a pat-down search, police only need to have reasonable suspicion. They can't just walk down the street and give somebody a pat-down search for no reason. But the courts have ruled that a pat-down search is acceptable if police have reasonable suspicion. Now, a pat-down search has some limits, though. They can't look for anything but weapons. So if police are doing just a pat-down search without any probable cause, and they feel what appears to be a weapon, they can go take that, let's say out of the pocket or whatever. That's a legal search. But if they are doing a pat-down search, and again, this is without probable cause, and they feel something that appears to be a bag of marijuana, that is not permissible to take, not with only reasonable suspicion. So pat-down search may be, you pulled over for speeding, the police only have reasonable suspicion, they ask you to get out of the car, they pat you down, basically to make sure you don't have any weapons on you. That is okay. And if they feel a weapon, they can go get it. But because they don't have probable cause, they can't search for anything else. A consent search is simply when you give permission to search. If police pull you over for speeding, they have no probable cause to search your vehicle. They ask you, can we search your vehicle? And you say, yes, go ahead and search it. Then you've given consent, and they can search their vehicle. Consent is actually a little more complicated. It seems pretty straightforward. Like, obviously, if you give consent to search, then you can be searched. But who can give consent? Well, if you're under the age of 18, your parents can give consent to have you searched. If it's a vehicle, let's say that somebody borrows my vehicle and is driving my car and gets pulled over, and the police want to search it, and they ask the person to search the car, and that person says no, so they call me up and ask, can I give consent to search the car? It's my car. My name is on the title. I can give consent to have my own car searched. So who can give consent? Well, who has the ability to give consent sometimes has to do with who owns the stuff. Not always, though. If it's a house, if it's my house, I can give consent to have the house searched. And if you're living in my house, let's say you're one of my children, and you're 17 years old, without a doubt I can have you searched. If you're 18 or 20 and living in my house, can I have you searched? Nope, but that room is not really your room. It's my room, it's my house. I can give consent to have my house searched. If it's a husband and a wife, and they both have the right to give consent, and if one says, go ahead and search, and the other one says, don't search, even though the police have consent by one person who has the ability to give consent, the answer is still no, because one person said no. If it's let's say 3 roommates living together, and one gives consent to search, they can give consent to have shared space searched, like maybe the kitchen or the living room or something like that. So consent actually becomes it's fairly straightforward if it's just, hey, may I search your purse? And you say yes. But it becomes a little more difficult when it's questioning who owns the thing, how old are you, stuff like that. If something is in plain view, police don't need a search warrant to get it. If police are where they have a legal right to be, so let's say that police are walking down the street and they see growing in the window of a house marijuana. That's in plain view. They had a legal right to walk down the street. They could see it. They can go in and take it, even though they don't have a warrant or probable cause. Or if they go into a house to conduct an arrest warrant, and while they're in that house, they notice, let's say, something illegal, like a meth lab, then that meth lab is in plain view, and they can take that. Hot pursuit is a rare one, but if somebody is chasing after somebody else, let's say that you are the criminal, you've robbed a convenience store, I'm a police officer, you go running on foot, I chase after you at foot, you run into a house. Now, I don't have probable cause to enter this house, nor do I have a warrant, but because I'm in hot pursuit, I can also enter that house. And let's say that while I'm in that house, I notice that there's something illegal in that house besides you. Let's say I notice that there's, again, a meth lab or something that's clearly illegal, something that's in plain view now that I'm in the house. It was a legal search to take that meth lab because I was legally in the house because of that hot pursuit. Again, kind of rare, but it is still an exception. Another one are vehicles. And really what you need to know about vehicles is police need probable cause to search a vehicle, but they do not need a search warrant. So probable cause is sufficient to search vehicles. When it comes to exigent circumstances, which really means emergency circumstances, or exigent situations, if you prefer, that is an emergency that gets police in the door. Let's say it's a 911 call. Police show up at the door, no one answers. They're afraid that maybe somebody is injured inside or had a heart attack or something, so they enter the house. Now, they've entered without a warrant, and they don't have probable cause. But it was an emergency that got them in the door. And then let's say that they notice something there. Let's say that there's something illegal sitting out on the counter. Now that is in plain view. The exigent situation got them in the door. They're driving by, they see smoke billowing out of a house. They go in, they rush in to make sure that no one's injured or whatever. That would be an exigent circumstance. When it comes to borders and airports, the simplest way to put it is we really don't have Fourth Amendment rights there. Police and the government can search us. We know that we are searched when we come from like the Canadian border. Let's say we're visiting Canada and come back to the United States, or same thing with Mexico. We're going to be searched there. We're on flights. We're going to be searched there, or we may be searched there. Those searches are legal. The courts have ruled that there's such a danger to society that those searches themselves are okay. Student searches, those are searches of students. Now, police officers, in order to search a student, need to have probable cause. However, the Supreme Court has ruled that students being searched by teachers or other school officials only need reasonable suspicion, or that school official only needs reasonable suspicion. It came about through a case called TLO versus New Jersey, and I'm not going to go over that whole case today. But if you want to read more about that, that's the case to look at. But students do have Fourth Amendment protection in school. But it's a lesser standard, at least when it's coming to school officials searching students. Police officers still need probable cause to search a student. And the last one here is sobriety checkpoints. The Supreme Court ruled that sobriety checkpoints are legal. Now, sobriety checkpoint would be stopping every vehicle to make sure that the driver is not drunk. Now, this is a probable cause-less search, but the courts have ruled that because of the danger of drunk drivers, that a sobriety checkpoint, even though it is a probable cause-less stop, is still an acceptable stop. Okay, that's again a real quick overview. That may not be sufficient to truly understand this, but I wanted to give a quick overview for a review, or if you missed class and need to get some of that information.